Do you think the procedural rules now clarify the definition of terrorism and terrorist acts?
Well, mainly it didn't because it has to abide by the law, and the law is very, very, should we say, horrible. The two problems here, Gretchen, is first the definition of terrorism is overbroad under the law, and that's what the even the procedure will define it. Is any person who commits an act intended to cause severe interference with critical infrastructure. So basically, you are being punished for what they are perceived to be your intention. And secondly, what is severe interference? What is critical infrastructure? Pag nag-rally ka ba and you cause traffic, is that severe interference? Or if you hold strikes or on very important government offices, is that so all these things depends on whether or not the police thinks you intend to commit quote unquote terrorist act. You're being punished for your intention.
Okay, attorney.
Secondly, the
Yes,
power of
go
the
ahead.
Anti-Terror Council is so huge, so big, and so large that the designation, for example, it shouldn't have been allowed to exist because designation is administrative, meaning it's the Anti-Terror Council, who is the judge, jury, and executioner here, who will designate you as terrorists. And the moment they designate you, it has already an impact. You can, in fact, be arrested, or in fact, your assets frozen, or your bank accounts closed. So basically, that's the problem. And in designation, for example, well, if they designate you, the burden is on you to file a petition with the with the Court of Appeals to question your designation. So why did the court consider this constitutional? In the old law kasi, the military or the police will have to file a petition in court to designate you as a terrorist. Now, they don't even need to do that. Whereas in court, they need to present evidence. The burden is on them. Oh, yan, siya, terrorist siya, this is the evidence. Dito, they designate you, and if you want to question it, you yourself has the burden to file a petition in court. So basically, that's the problem here because the law is in itself horrible. Therefore, the IRR cannot go beyond the law and merely mimics what the law says, and cannot go beyond that.
Right, attorney. As we know, this law has gone through so much. The SC has already ruled that two provisions are unconstitutional. There have been public consultations that were done, according to Chief Justice Gesmundo. Are you saying, attorney, na kulang pa ang pagre-refine dito sa batas na ito? And having said that, ano pa ba yung pwede nating gawin? Kasi nag-rule na with finality yung SC. Do we still have any moves left?
Yes. Well, yes. For example, designation. I mentioned to you the burden is on the part of the person being designated rather than on the part of the Anti-Terror Council. The second is the procedure allocated 20 days for you to file your opposition. Can you imagine it, Gretchen, Sean, and Danny? You're an ordinary person. You don't have a lawyer. You don't have access with Anti-Terror Council documents. Why did they designate you? How can you file in 20 days? What if you filed on the 21st day? Is your petition no longer allowed? Dapat, ang rules of procedure is this. Anybody designated can question it anytime. Whether you want to question it in 5 days or 30 days, there should be no limit. Kasi people, activists, ordinary, opposition people, wala namang access yan sa lawyer kaagad-agad na in 20 days you can file your opposition. So, things like that. Now, with regards to the second question, can we do something about it? Of course, as I've always said, no, tatlo lang naman ang laban dyan, no, sa korte, sa kongreso, sa kalsada, meaning kalsada is to protest. Well, sa korte, of course, we can file a petition later on. Pag may actual case na, in fact, there had been cases already done na designated yung ilang innocent people, no, indigenous people, for example, like Wendell Bulingit. So maybe that will be a cause for the Supreme Court to review its previous decision because no decisions naman are cast in stone. They can always be abandoned or reversed by the Supreme Court. The second is in Congress, if the House and the Senate can, of course, pass a bill that will repeal at least the onerous provisions, yung mga dangerous provisions like administrative designation. I-repeal yon. If you want to designate a person, you go to court. You place your evidence there, and it's your burden to prove it rather than the accused to prove his or her innocence. So it can be done too. And of course, human rights lawyers and advocates can continue protesting, hoping that the government will listen to their plea because this law can really be used against anybody that the government dislikes. If I don't know this administration, but it doesn't matter. If it's a law, the next administration, what if another someone similar to President Duterte wins in the next election? Then all of us will have a big problem. So I guess this is there should be, while we are concerned with terrorism and terrorism must be condemned and so on, opposed, we do not allow naman government to have such power like the Anti-Terror Council to
Attorney,
designate red tag a whole lot of people.
Attorney, but just the fact that this exists, no, does that signal that the judicial process is perhaps too slow in being able to, let's say, target the terrorists? That's why there's a broadening. That's why there's a need for this. Is there a rationale for that to begin with? And then there is, of course, safeguards necessary.
Well, the moment we begin along that road, that's a difficult part because it's also too slow against rape cases. It's also too slow against murder. So we bypass all the judicial processes. What we need is not an anti-terror law. Then what we need is a reform in the judiciary to make cases work. For example, the fact that during the drug war, thousands have been killed, at least 6,000 as far as the police is concerned, 20,000 as far as the victims are concerned. Well, until now, how many cases are there? So we need to reform the judicial system rather than create a law that, if a police kills somebody, then that police should be killed, or, you have an anti-terror law on the reverse. So
Attorney-
that's my opinion there.
Attorney, I want to get your opinion on this. The time that this was used on a high-profile case was the one with former Congressman Arnie Teves. Dinesignate po siya na terrorist, finreeze po yung kanyang assets. What are your thoughts on that and using this law in his specific case?
Yes. Well, actually, we were surprised because when they were discussing it before the Supreme Court, they were discussing the Bin Ladens and the Abu Sayyaf and the Maute and so on. And then here comes, why couldn't they charge him with murder and, a whole lot of other crimes under the revised penal code? So that's already a sign that they have a very vague interpretation of what terrorism is. Because everybody thought terrorists are Abu Sayyaf and so on, not congressmen. There are congressmen who are charged with murder or other illegal acts, but you don't use that against them. I'm not saying that they should not be charged. I'm just saying it was surprising for us because they never mentioned the likes of Congressman Teves in the deliberations. They were always portraying these terrorists who the courts cannot catch and so on. So for me, that's really one example.